Hi, welcome to the Community Classroom. This is Dr. Tracey McCarthy, psychologist, attorney, and educator, and we are continuing on with this response series. Today we're going to address the issue of law. We're going to focus on criminal law and civil law, and we are going to address the issues of theft, conversion, and conspiracy. I'm going to start off with a quote. I'm going to try to speed these up a bit if you don't mind. Well, even if you do mind, I'm still going to try to speed them up because they're becoming exceedingly long, and I'd like to keep the videos to about 10 to 15 minutes. But anyway, let me give you this quote, and it's from The Atlantic, and the quote is regarding the apology for slavery that was provided by various leaders in Africa. And this is regarding the issue of apology from the Nigerian tribal chiefs. This is a quote from the article. In Nigeria, some tribal leaders have taken the position that since slavery occurred long ago, the perpetrators of the crime owned their sins and did not bequeath remorse to their descendants. In 2009, when Nigerian tribal chiefs sought a constitutional amendment formalizing their influential role in the country's governance, the Civil Rights Congress of Nigeria, a human rights organization, encouraged them to apologize for their role in the Atlantic slave trade. These efforts failed. In declining to apologize, one elder told a Nigerian newspaper that his people were, and this is in quotes, not apologetic about what happened in the past, unquote, explaining that the slave trade was very, very legal when his forebears were involved in it, and emphasis on very, very. Now, what this quote indicates is an ignorance, a lack of appreciation for the different areas of law and the different theories and philosophies of law. There's something in law called mala in se and mala prohibita. And mala in se and mala prohibita basically talk about what type of wrong we're dealing with. They're Latin phrases. They are Latin phrases basically dealing with the issue of evil and morality. And so the Latin phrase mala in se basically says that it's a wrong, it's an evil in and of itself. And this means that the conduct is assessed as sinful or inherently wrong just by its very nature. It's regardless of the circumstances, it's regardless of the regulations or any laws governing the conduct. It's wrong in and of itself. And there are certain crimes that fit into that, such as murder, theft, things like that. You know that they are just inherently wrong, even if you don't have a regulation against it. And mala prohibita basically is about things being wrong because they've been determined wrong by rulings, rules in a society, laws, ordinances, things like that. Okay, and so there are two different areas of law, primary areas of law. There are many more areas of law, such as admiralty and things like that. But we're just going to focus generally on criminal law and civil law. And then there is another area of human rights law that is emerging and growing, in fact, which also fits under this discussion. So let me give you the brief, quick and dirty understanding of criminal law. Criminal law basically just involves a wrong committed against a sovereign. It's in violation of the rules, the codes of conduct, the ordinances, the statutes, the constitutions of a culture, a tribe, a nation, or some sort of a body of government. And while there are human victims of crime, the crime is technically against the state or the sovereign. This is the reason why the prosecutor takes on the case and prosecutes it on behalf of the people. This is also the reason why if someone does not want to press charges, so to speak, it doesn't really matter because it's really the state's case and the state decides whether or not the charges will be pressed, not necessarily the personal victim. And so in that way, the prosecutor serves as the proxy. Now, crimes can be minor in terms of action and consequences. So you have misdemeanors, which are minor in terms of action and consequences. And then more serious crimes would be felonies. And then capital offenses are considered the most serious because they involve the possibility of death. It's the death penalty as the consequence. And crimes involve actions such as theft, burglary, robbery, identity theft, exceeding the speed limit. So there's a whole range of things that fall under the definition of crime. There are two elements of crime that you need to know about and that need to be proven in a court of law. And they are what's known as the actus reus and the mens rea. Now, the behavioral element of a crime is known as actus reus, and it is the actual volitional behavior that is required to commit the crime. So if it's theft, it's actually the stealing, the act of stealing. And the mens rea is the culpable mental state. Now, some people refer to this in common parlance as sort of the guilty mind. And the guilty mind is a little harder to prove, as you can imagine, than the act itself. And I'm going to give you, for instance, in the current situation with the Molly Tibbetts situation, I understand that it was reported that the accused claimed to have blacked out prior to the crime commission. And this assertion of blacking out prior to the crime commission is it can be construed as an attempt to challenge the mens rea component of crime commission. So the crime occurred, but the person is claiming to have no recollection of this crime occurring whatsoever. Okay, and so then civil law, which is the other arm here. Civil law involves a non-criminal action. It involves private party versus private party, even though the government may be a party. This doesn't automatically translate into the government involvement being one of a criminal litigant. And so civil actions and civil law can actually also be related to criminal law actions. And you saw this in the case of O.J. Simpson, wherein there was an action of acquittal for the criminal case, but then for those same issues, there was a later finding of culpability based upon the private civil claims. And so civil actions include things related to like contracts, property, family law, wills and trusts, probate, business organizations, torts, things like that. Okay, so when we talk about this issue of slavery, the issue of theft comes up. Well, sometimes people don't talk about it being a theft issue, but I'm going to talk to you about it being a theft issue. So what is theft? We're going to talk about the crime of theft and also the civil issue known as conversion, which is related to it. It's sort of like the cousin of theft. Okay. Conversion is the cousin of theft. Okay. I never thought about that before, but that makes sense. All right. So theft is simply a crime involving taking. It's the taking of something, someone else's property without their requisite permission to do so. It also involves taking someone else's property with the intention of permanently depriving them of the possession of the property. It doesn't matter whether or not the person had some Robin Hood purpose for the taking. You know, they're robbing from the rich to give to the poor. It still is an illegal taking. And when you think of theft, it generally involves things like taking tangible items like cars and tables and even stealing land, and even intangible items such as like the funds from a bank account with like electronic transfers and things like that. And property, as we know from history and current events, can actually involve people. So I want you to hold on to that. Property can involve people. Okay, so since we're in the community classroom, I have a classroom question for you. It's a question. If people can in fact be considered as property, who held the property right in the person prior to the moment at which they became assumed as the property of another? All right, second question. If a person can be considered in fact property, does the taking of the person without permission of the person and with the intent to deprive the person permanently of their property right, does that constitute theft according to the definition that I've already provided you? For all of you sharp folks out there, I know that you already know that was a rhetorical series of questions. All right, so let's move on to conversion, which is the cousin of theft, as I told you. Conversion is a civil action. Conversion is simply a civil action based upon the taking of someone else's property with the intent to permanently deprive them of such. And so when people sue for conversion actions, they either sue for the return of the property, or they can sue for the full value of the property taken. In some instances, even if the property is returned or repossessed. And so I want to tell you about a defense for conversion, because sometimes people will say, what if the person didn't mean to steal it? And so accidents can be used, or mistakes can be used as a defense to challenge the mens rea element of even theft. So let's say a person took the wrong umbrella from the coat and umbrella check stand when there were multiple umbrellas that look substantially similar, a bunch of black umbrellas, a bunch of blue umbrellas. Now, in some cultures, there are people called boosters. And boosters, if you don't know what they are people that go into stores and they steal things and then they sell them, usually on the street, at a cut rate. And when they steal the property and they transfer that stolen property to another person, the issue of receiving stolen goods or stolen property comes up. And so what is receiving stolen property? Receiving stolen property is basically acquiring or coming into possession of something that has been taken unlawfully. It's been stolen, it's been embezzled, or by any other manner. And so if two parties collude in theft and receiving of transferred stolen goods, then you have what is known criminally as conspiracy. And so conspiracy is simply two or more people getting together to plan to do something that they have no business doing, such as committing the crime of theft. Now, chattel slavery, let's look at it from that vantage point. Okay, so you have the crime of theft in the person, and that includes the ownership and the possessory interest. And also you have the issue of depriving the person of whatever property that might have been theirs when this person was stolen. Okay, and so hence the reparation of land for those who have been identified as native with reservations. The reservations serve as some sort of repair. If you've ever been to a reservation, however, you would know that the reservations definitely do not serve as anything remotely resembling repair. Reservations, in fact, on the outskirts of some reservations, sort of look like prison camps, because there is sort of like barbed wire, razor wire sometimes around some reservations. Okay, so, and then when you transfer that human being, that person, that stolen property, that becomes the receipt of stolen goods yet again. And so together you have this issue of conspiracy with the two initial instances of civil conversion and theft. So you've got conspiracy going on as soon as you have that transfer where people have been plotting and planning to do this thing. Okay, so we're going to wrap this up with talking a little bit more about conspiracy. So conspiracy, there are two primary types of conspiracy. One is called a chain conspiracy, and the other one is like a spoken wheel conspiracy, also known as a hub and a spoke. So think about a wheel, like a wagon wheel. So when you have a chain conspiracy, basically what you have are conspirators who act separately but successively. And so the chain conspiracy members, they might not even know each other. However, everyone is responsible, even though they don't necessarily know each other in the conspiracy. There's a good case for looking at conspiracy. It's United States versus Warner in 1996, if somebody's interested in looking that up. Okay, and so the wheel conspiracy basically involves a single member, or what you would think of as like a ringleader. This person would engage in separate deals with two or more members or groups, even though they have a shared common criminal purpose. They also don't necessarily have to know each other. but they are operating based upon the ringleader orchestrating all of these things. So let's do a quick recap here. In the instances of slavery, we could use transatlantic slave trade, the Barbary slave trade, the trans-Saharan slave trade, the Libyan slave trade that's been going on. In all of those instances, what you have is a theft of a person. You have a transfer of that theft. And you also have the deprivation of property and the transfer of that property multiple times, actually. And you also have conspiratorial actions. And so the conspirators would be the initial slave catchers. Then each time you have someone who takes possession of that property, or they're colluding with this person or this entity, this group, to transfer possession successive times, then all of these entities are perhaps culpable in this overall theft and receiving of stolen goods and conversion. So they are, it's why you have like co-defendants. Okay, so I'm hoping that this information was helpful. Remember, knowledge is power. Take care and see you soon. Before I go, one addendum. There was also slavery that took place on this continent separate from the transatlantic slave trade. And so this information would apply in those circumstances also. All right. Again, take care. See you soon.